agencies. So next I want to bring in Jonathan Dye. He's going to give a welcome speech, to everybody, and then we're going to go ahead and jump right in and get started on this panel discussion.
Good evening, ladies and gentlemen, and good morning, friends in the Asia Pacific region. I understand it's 7 o'clock in the morning there. Before we proceed to the panel, we'd like to once again to thank all the sponsors and endorsers for their continuing support. And I would like to make a special mention of the contribution of a special Canadian who initiated the cross-Canada campaign to free Meng Wanzhou and has been the driving force behind it. And that fine person is Brother Ken Stone. We are also excited to see more and more people, especially young people, joining our campaign and movement to restore Canada to the status of a peace-promoting country which develops its own independent foreign policies. On this occasion, I'm happy to announce the forming of a youth organization, the CCCCD Youth Association. Anti-imperialism is the core tenet of the CCCCD Youth Organization, its operation, and works to fight for a peaceful and cooperative world, which is run in the best interest of working people by working people. Aidan Joner is the president of the CCCCD Youth Association, and he says, xenophobia is rampant in Canada. Anti-Asian hate crimes are on the rise, enabled by a century-long policy of attacking China and the Chinese Canadians. Canada's foreign policy towards China is one designed to stun our nation's growth. While enabling the American-led Cold War on China, we work to oppose these actions unapologetically. Congratulations, the CCCCD Youth Association, and the future of the world belongs to young people like you. Interested persons can follow the CCCCD Youth Association on social media for announcement on future actions and campaigns, and consider setting up an annual donation on their website today. Now, let's come back to the topic of this evening's panel. It is sad that after 2.5 years, we are still here fighting for the freedom of Miss Meng Wanzhou. The arrest of Madame Meng, a cowardly act of kidnapping and hostage-taking, was a colossal blunder on the part of the Trudeau government that has cost Canadians dearly. Now, the Trudeau government chose to follow the diktat of the US government in arresting Meng Wanzhou at expense of Canadians' national interest should cause us to question whether we have any sovereignty left in this country. I want to point out that China, which boasts the most prosperous economy in the world, has for 42 years hardly engaged in and not engaged in any war, and has been promoting peace, harmony, and economic development around the world. While the USA has, for decades, been engaged in launching numerous destructive wars, leveling economic sanctions against the 59 countries, and causing millions of deaths around the world. Canada is the only G7 country that does not have a shameful history of invading and looting China. And it was Pierre Trudeau, Justin's father, who initiated the good relationship between Canada and China 51 years ago. Pierre Trudeau's independence of a foreign policy ushered in 5 decades of prosperity with China, to the point that China is now Canada's second largest trading partner. In closing, we call upon the Prime Minister and his government to restore our mutually beneficial friendship with China by immediately releasing Ms. Meng. Thank you very much for your kind attention.
Fantastic, Jonathan. Thank you so much for being here for today's event, and also giving that really great recap of the great relationship that Canada has enjoyed with China. And this is something that I think all of us are very concerned about, and this is why we have this campaign. This is why we make YouTube videos. Is we want the relationship between these two great countries. Interesting enough, Pierre Trudeau, he actually opened up a relationship with Canada and China, actually before the United States did. So, Canada's had a great history, with the country of China. The two have benefited tremendously from each other. And this is something that we want to continue to see in the future. Now, everybody, I'm very honored to be, hosting this event on my YouTube channel, but also to be a panelist and be joined by three very distinguished speakers here. I think all of you are going to really, really enjoy them. I'd like to bring them all to the screen right now. And, I'm going to give you a brief introduction of all of the panelists here. So our first is actually going to be, Chris Black, and he is a Canadian international criminal lawyer, a writer, an activist with over 40 years of experience, including 20 years, on war crimes cases at international tribunals. He is involved in many campaigns in Canada and internationally for social, economic, and political justice. His novel, Beneath the Clouds, deals with Canada's subservience to the United States and Western political control of the international justice system. I think we're really going to, enjoy hearing Chris's updates. He's going to be updating us on Meng Wanzhou's case. As many of you know, it has been delayed until August. And so we're eagerly anticipating the next phase of that and hopefully getting a decision, later this year. So, Chris Black, who is an accomplished lawyer, is going to be updating us on that. Another panelist is Sheila Xiao. She is a researcher, a data scientist, and a community organizer, a second-generation Chinese American who was raised in San Francisco, California, Irvine, and the University of Hong Kong. She is a tireless advocate for communities of color and the co-founder of the organization of Pivot to Peace. Sheila and I actually first met. She sent me an email many months ago, might have actually been about a year ago, as, this tension, was growing. Obviously COVID-19's impacted our world. There's been a tremendous amount of Asian hate crime. She just reached out to me via email, said she was starting this organization. I said, hey, what can I do? And she said, just follow us on Twitter, retweet us, just support us. We're all working towards the same thing, better relationships. So I'm really excited to have Sheila on the panel and to, hear her insights as well. Our fourth panelist is Mei Chu. And Mei is a member of the Progressive Chinese of Quebec, an organization to fight anti-Chinese racism in Quebec. Mei has fought against South African apartheid, Israeli apartheid, police brutality, and against Bill 21. She has worked as a community organizer for housing rights and against poverty. Professionally, she is a mediator and a family attorney, and she initiated the March Against Asian Hate Crime on March 21st, which inspired marches all across Canada. And this is really, really, really important because, and this is something that we want to add into this discussion today, is really the rise in anti-Asian hate crime. I live in Vancouver, and a Bloomberg article just, published last week highlighted that Vancouver is actually the capital of Asian hate crime in North America. A tremendous amount of, incidences have been reported. This is something that we need to discuss about, and I'm really excited to bring in, Mei for her insights. So these are the four panelists, and then myself, I'm going to be the fourth panelist. I'm going to be closing out the discussion today, but I'm really excited myself to hear from these panelists and their insights. And we're going to start with Chris Black to hear about the legal proceedings and some of the important updates in the Meng Wanzhou case. So, Chris, the stage is yours.
Thanks very much. It's a great honor to be here and to join everybody else in this panel. It's a very important one. And I was assigned to talk about the legal issues and what's involved and why Meng was arrested in the first place. So, I guess I'll start out by saying that we object to the arrest and detention of Meng Wanzhou because it's based on a U.S. extradition request that was made for political reasons. The objective being to use her detention as a bargaining chip in trade negotiations between China and the United States as harassment of and an attempt to discredit Huawei, to prevent it competing with US and EU tech companies, and as an attempt to enforce the illegal economic embargo or economic warfare being conducted by the United States against Iran. It was meant to send a message and is a warning to others. Now, President Trump made it clear in a statement days after her arrest that he would certainly intervene in the case if it led to a better outcome for the US in trade negotiations. Her lawyers rightly called this abhorrent, for it proves that Meng is in fact held hostage to force China to bend to its will. The fact that Prime Minister Trudeau was made aware of the American request days before her arrest, confirming John Bolton's statement to the same effect, also establishes that the matter was discussed at a high political level before the request was sent to Canada. Further, her arrest took place during a period of increasingly hostile and aggressive propaganda and actions against China by the United States, Canada, the EU, Australia, and Britain, the former colonial powers except for Canada. Although you can view Canada as a colonial power with respect to its own indigenous peoples. It has also to be seen in light of the illegal arrests of citizens of other nations the US has targeted as enemies, while no such arrests have taken place of employees of European, Canadian, or other companies doing business with Iran. So Meng's case can also be seen as a case of selective prosecution, which is a defense available to Meng, since if it is established, the courts can stay the charges, and as it is considered unjust to charge some but not others. For instance, we can cite the cases of Alex Saab, a Colombia-born Venezuelan businessman who was appointed as special envoy by the Republic of Venezuela, who was en route to Iran to buy medical supplies for the people of Venezuela, when on June 12, 2020, he was detained in Cape Verde in Africa, thrown in jail, held in solitary confinement, psychologically tortured, and then finally got bail and released, although the courts in Cape Verde ordered his extradition to the United States. Fortunately for him, the African Bar Association and the Economic Community of West African countries objected, and that has been stopped so far. We can also cite the case of Moon Chol-myung, a North Korean businessman who was also extradited from Myanmar to the United States in March of this year, on similar charges that he was helping North Korea, and all he was doing was helping North Korea obtain necessary supplies. Now, the connection between these cases for the Americans is that in these transactions, a SWIFT bank clearing system was used to transfer funds. And in fact, this is the only claim to jurisdiction that the Americans attempt to make. Now, I shall deal with this a bit later. There have also been several Russians detained by the Americans under similar claims. We haven't got time to go into all those. So we see a pattern of illegal actions by the Americans against nations in which they use people as pawns to effect their hostile foreign policy. It's also indicated by the fact that the United States chose to target an employee of a company instead of the company itself, which it usually does in these cases, since the employees are acting under the company instructions, and it's the company, the corporate entity, which is responsible for the actions of its employees. Now, I've been asked to tell people, explain what extradition is. What is it? Extradition is simply the legal process by which one state seeks to have a person who committed a crime in that state or was convicted of a crime in that state returned to that state from another state in which they are now located. This also takes place between provinces in Canada or states within the United States when someone has committed a crime in one jurisdiction but is located in another jurisdiction. Since all nations are sovereign, although the Americans try to deny that, such requests are made possible by treaties between various nations. And Meng's case is controlled by the extradition treaty between Canada and the United States. The extradition hearing is not a trial. The requesting state, here the American state, is only required to prove that it has a prima facie case against a person. That is, a case that, if not answered, could result in a conviction at trial. However, the arguments put forward by her legal team with respect to the substance of the charges about prosecutorial misconduct by the Americans, deceiving the Canadian court on the facts alleged, and what the real facts are all meant to establish that the U.S. does not have a prima facie case and that the allegations are political in nature. So that requires us to look at the extradition treaty, and the controlling paragraph of that is Article 4, subparagraph C, which says, extradition shall not be granted in any of the following circumstances. Quote, when the offense in respect of which extradition is requested is of a political character, or the person whose extradition is requested proves that the extradition request has been made for the purpose of trying or punishing him or her for an offense of the above-mentioned character. It is important to note that the article makes it an obligation on the requested state, which is Canada in this case, to refuse a politically motivated request. The requested state does not have any discretion in the matter. It must refuse the request in such circumstances. Article 9 is also important because it states that the request for extradition shall be made through diplomatic channels. This is important, an important factor, because the request is sent by the U.S. State Department to the Canadian Foreign Ministry. Therefore, the Minister of Foreign Affairs, the Minister of Justice would have received copies of the request and had the right at that time to refuse the request, knowing as we do, and as they certainly did, that the request had no legitimate basis and was politically motivated. By refusing to reject the request at that point, and instead sending the file to the local federal crown prosecutor in British Columbia to be dealt with by the courts, the federal government arguably violated both the treaty and Meng's right of protection under Article 4 of the treaty. Indeed, the federal government can step in at any time under Article 4 to reject the request and free Meng. They can do it today. They can do it tonight. They can do so even if the judge in this case orders her extradition. I had a case once, 30 years ago now, of a man accused of 2 murders in the United States who faced a gas chamber. The Americans succeeded in the extradition hearing, and he was ordered extradited by the court. But I was able to arrange a meeting in Ottawa with the then Minister of Justice, Mr. Bouchard at that time, and was successful in getting him to agree not to send the man to the United States unless they agreed not to seek the death penalty. And this fact was also stated in the famous letter of June 3rd, 2020, requesting Meng's immediate release in order to soothe tensions between Canada and China, which was signed by a number of notable lawyers and former ministers, including the former Minister of Justice, Alan Rock, former Minister of Foreign Affairs, Axworthy, the former Supreme Court judge and former professor of mine, Louise Arbour, the very learned Toronto appeal lawyer, Brian Greenspan, and several other former ministers, law professors, advisors to Prime Minister Trudeau, and high UN officials such as Louise Frechette, who was at one time Deputy Secretary General of the United Nations. Though it's of interest that the letter signed by those people only wanted the release of Meng in order to obtain the release of the 2 Canadian Michaels, the Canadians arrested in China, so that Canada could have a more hostile policy against China. But we'll leave that for others to comment on. Now, Meng's defense team has presented these arguments to the court and the government, but they've also challenged the entire basis of the U.S. indictment against Meng. For the indictment contains several counts, most of which refer to the violations of the U.S. sanctions against Iran. But several counts are couched in terms of fraud, but they're still relating to violations of the Iran sanctions, so-called. Now, the U.S. had to do this because Article 10 and Article 2 of the treaty also stipulate that the offense that they charge Meng with must also be an offense in Canada and provable in law as such an offense. In other words, no one can be extradited to the U.S. from Canada unless the crime they are accused of is also a crime in Canada. Okay, fraud is a crime shared by both countries and is listed in the treaty. But where is the fraud in this case? This question requires us to look at several factors, as the Meng defense has done. First of all, the U.S. indictment against Meng and Huawei and Skycom, a subsidiary of Huawei, of trying to violate the illegal U.S. sanctions against Iran seems to be the principal charge. Canada has no such sanctions imposed against Iran at this point. That's the real essence of the matter. When one reads the U.S. indictment, it is clear the main thrust of the crimes alleged is ignoring the illegal U.S. sanctions against Iran, of trying to bypass those illegal sanctions, of ignoring the emergency powers given to the United States president under which the sanctions, so-called, were issued. The Canadian prosecutor and U.S. authorities tried to mask the fact that the central elements of the indictment concern the Iranian sanctions, and they do so by claiming that Ms. Meng misinformed a bank, in this case HSBC, Hong Kong Shanghai Bank Corporation, at a meeting which took place in Hong Kong, China, and did not disclose her company Huawei was going to use funds from the bank to engage in dealings with Iran. It now seems clear from the documents the defense has obtained that Ms. Meng and Huawei were in fact open about that, and HSB was informed of the true nature of the transaction, so that no funds were obtained by false pretenses as alleged. Worse, it is clear that the U.S. authorities tried to mislead the Canadian authorities and the court by disclosing a doctored PowerPoint presentation by Meng to HSBC that had the information she gave to HSBC removed. In most cases in this country and in the common law system, most courts would consider that an attempt to deceive the court and would stay the proceedings at that point, because then the prosecution and the party bringing that forward could not be trusted. And it's an abuse of power, abuse of the court proceedings to do that. The ordinary citizen will then ask, well, what is it to the United States what happened between a Chinese company and a British bank in a meeting in a Chinese city, and when the bank has not complained to anyone that they were defrauded, when the officials of the bank have not been similarly charged, and no charges have been laid in China, which had jurisdiction over the matter, or in the UK, which arguably maybe had jurisdiction. But the US claims jurisdiction because they argue money which would have been transferred through the SWIFT banking system, which would have flowed funds through their wires for a few milliseconds, and they would travel through wires in the United States. This, they claim, gives them jurisdiction over the matter, and they then claim that HSBC would be subject to heavy losses due to the immense fines the Americans could impose on them for violating its illegal sanctions against Iran. In other words, their claim to jurisdiction is ephemeral at best and arguably non-existent. There has to be a substantial connection between the state laying the charge and the criminal activity alleged. They cannot make such an argument in this case. The constant attempt, in fact, by the Americans to impose American law on the world and to claim that it has worldwide jurisdiction fails in this case, as it must do in all cases. Otherwise, the United States would be master of the world, and the sovereignty of other nations and the protection they afford to their citizens would completely vanish. Now, what losses would HSBC have arguably incurred? According to the Americans, they would have been hit by heavy fines, but HSBC can argue that they would not have suffered any losses at all. If HSB were subject to charges by the United States, they would simply argue that there is no case to answer because the American sanctions are illegal and therefore void, and no court could make them pay an illegal fine. They did not and could not in law suffer any legal consequences. The fact is, though, the Americans would de facto try and do something. But this leads us to consider what the so-called sanctions are and why they are legal and why they use the word sanctions. Sanction implies that the country imposing them has some sort of superior right, some sort of superior moral position over the nation they're imposing them, some sort of higher authority over a nation they're imposing them on. And obviously, each nation is sovereign. The United States has no such higher position, nor does Canada or any other nation. And the United States authorities are subject to American law. So we have to remember that Article 6 of the United States Constitution states, in part, that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. Now, the U.S. signed and ratified the UN Charter, and it is therefore part of the United States domestic law and cannot be overridden. The UN Charter reserves the right to impose sanctions or economic embargoes against a sovereign nation to the Security Council. No single state or group of states, no matter what they argue, had the right to abrogate to themselves the right given solely to the Security Council on Chapter 7 of the UN Charter and Article 41 dealing with the ability of the Security Council to impose economic embargoes against a nation. Therefore, the sanctions the U.S. claims to have imposed are void under U.S. law. They do not legally exist. In fact, the Canadian government, by cooperating in pressing this American claim against Meng and Huawei, undermines its own sovereignty and protection of its own citizens. For if the U.S. false legal claims are accepted, then the United States could demand the extradition from Canada of any Canadian business person who engages in similar transactions with Iran, when in Canada they could not be charged at all. The U.S. is adept at concocting fraud charges, and what would Canada's answer be then? Further, Canada, by cooperating with the U.S. in this case, is directly supporting the illegal U.S. sanctions against Iran, which also adds to the political nature of the case. Lastly, the Meng defense has presented a strong case that Ms. Meng's rights were violated when she was detained at Vancouver Airport on December 1st, 2018. Canadian law requires anyone detained by the authorities to be immediately informed that they are under arrest, the reason for their arrest or detention, their right to a lawyer, and their right to remain silent. She was not informed of her rights. Instead, her rights were continuously violated. She also had a right that her property not be subject to illegal search and seizure. Yet the sequence of events shows that she was held incommunicado for several hours, subjected to aggressive questioning, her mobile phone seized, was browbeaten into giving up her passwords, never told why she was being held, her right to remain silent, to have her property secure, etc. Unfortunately, breach of fundamental rights by the police in this country is all too frequent in many criminal cases, as most criminal lawyers are aware and have experience with. But in this case, these circumstances add to the evidence that her arrest was a political one. Because under the treaty, the Canadian authorities are not supposed to help the requesting state, in this case, the United States, find evidence to support their request for extradition. That's not their role. Their only role is to act on the U.S. arrest warrant and detain her, advise of her rights, and leave it at that and for the courts to proceed. But instead, the RCMP and the CBSA acted as if they were agents of the American police. They may claim they were trying to find evidence of fraud, itself an improper action, but it's much more likely that they wanted to have access to her phone to obtain business information about Huawei. In other words, they were trying to steal information and pass it to the Americans to be used against Huawei and, of course, against Iran and China for political purposes. And now we see for several months the argument about an RCMP officer who was involved in her arrest and who could testify about all those circumstances, refusing to come to testify and being protected by the government and so on. So in the end, it's clear that Ms. Meng's detention and arrest and the extradition request are politically motivated. And therefore, under the treaty, the government of Canada can and must release her. It's also clear that the accusations themselves, the cover of her being held hostage by the Americans and Canadians, has no basis either in fact or law, and on those grounds, the U.S. request must be rejected. So it's for all these reasons that we as citizens of Canada demand her release, because aside from the very serious economic and other consequences for Canada that have resulted and will result from her continued detention, it's the right thing to do.